if you don't put down a claim that you're aware of, if the claim arises, an insurance company will ask someone like me to investigate why you didn't declare that in your proposal form. Because the proposal form is the underwriter's friend. The policy is the insurance friend, but the proposal form is the underwriter's friend.
Because the motivation is always there from the physician side or the facility side to report
Notify,
any incident,
absolutely.
notify.
Yeah.
However, you know, as the usual trend with patients who go and complain, sometimes they remember after 2 years, 3 years, and they do without any notice.
Absolutely.
Nothing.
Absolutely.
You know, 3 years later they come
Yes.
and they
Yes.
claim or something happened
That's right.
during,
Well, Well, the time limit to file a claim is 3 years in torts, arising not from the date of the incident,
from the day you become aware of
but
it.
the day you became aware of the damage.
Yes.
And if you're a minor, you can claim 3 years from when you attain your majority. So if it happens when you're 5, you get to 16 or 18, I can't remember which one, and you can get 3 years from your 16th birthday, even though it happened when you were 5 years old. So there is quite a long time delay, but we'll come to this in a minute. In your proposal form, you have to make sure that you're very, very careful about what you disclose. Anyway, we'll come to that more in a minute. Okay, so what they agreed to do is to pay all defence costs incurred with the underwriter's consent. So basically, your underwriter approves who your lawyer is. Most commonly, the underwriter will appoint the lawyer on your behalf, and you simply have to get on and deal with the lawyer appointed by the underwriter. All right. So this is a typical type of exclusion clauses. You sometimes see this: any claim arising from any it's number 2. Any claim arising from any circumstances or occurrence which has been notified to any medical defence organisation. Now in the UK, you have a number of different defence unions, which are physicians, sort of organisations. Usually they're non-profit, like the Medical Defence Union, or the dentists have their own union. They also provide indemnity cover, but usually they give legal expenses cover. So, and they have helplines. So a physician has a problem, he can phone up his medical defence union, medical defence organisation, and ask for assistance. It's usually, on the other end of the telephone, it's physicians who also happen to be qualified lawyers. And they're very good organisations, but if you haven't notified them, this policy says we're not covering you. You have to go to them. It's a way to exclude. You see that quite often with the different insurance companies. Each will try to pass on the liability to the other.
Can I ask you something? We are not very good with the insurance.
Hang on a second. Can everyone hear? I tell you what. Why don't we? Could you give the microphone?
Of course.
And then perhaps we can.
If we go back.
Could you just wait a second? We'll give you a microphone.
Open it,
please, open. Push. Okay, then.
Thank you. So, if we go back to the previous slide, because we are not dealing. No, the one for the duration and the time of a claim.
Yes.
Can we just elaborate more?
Yes.
I mean, there is a time of insurance,
Yes.
which is the period.
Yes.
And if an incident happened during this period, the claim should be during this period,
No.
or you can go back to it later on. Say you had been insured between 2005 and 2006, and there was an incident which had been reported or retrospectively had been, and then the claim will come 10 years later or 5 years. Is it accepted?
Well, not under this policy. This is
Not
a claim,
under this. This
no,
is
this is a claims made policy. This means that the claim has to be made
within this
within
period.
the period of insurance. Now, the retroactive date can go back and say, if a claim is made going back to 2009, within this period you will be covered.
Okay.
Yes?
So the claim should be during the period of insurance.
Yes. So, say for example, an incident happens during the period of insurance, but you don't make a claim within the period of insurance, comes later. You are not covered by this policy. Policy won't cover you. Your next policy, your next insurance company may well have a retroactive date going back, and it may be a claims-made policy, and they would be covering that. So this is very clear. This is a claims-made. The claim has to be made, not the incident itself.
Within the period of insurance.
Yes. Okay, now this is the one that usually gets people spitting and kicking when they see this insurance policy. This is the exclusion clauses, remember, and it says excludes from liability any claim directly or indirectly caused by or contributed to by any act in violation of any law or ordinance. Now, medical malpractice under Article 343, 342 of the Penal Code are crimes. And it's not gross negligence, it's not, it's simple negligence. Now, there is a defence, which we'll come to later, that if you're not negligent, it's not a criminal act. But quite clearly, a criminal act could be simple negligence. Now, in the United Kingdom, simple negligence is not a crime. It's a civil wrong, or tort, as we call it. It comes from the French tort being sort of left, wrong. It means that any claim that's been, and usually what happens is this, an impecunious patient or plaintiff doesn't have any money to go to a lawyer, they don't have any money. So to advance their claim, they make a complaint to the police. There's no court fees to file, you have to appoint a lawyer, and the police then prosecute simple medical malpractice. If there's a conviction, liability, not quantum, but liability is guaranteed. It's fixed. If there's a final criminal judgment against the physician, that's it. Negligence is established. So in a way, it's an impecunious plaintiff, or a poor man's way to further a case. So we've got here any fines, penalties, punitive or executive damages. Punitive damages aren't awarded in UAE law, so that's a bit otiose, that's a bit unnecessary. But fines and penalties, the payment of the dia, or arsh, or gora aren't fines, so they should be covered under the policy. These are liquidated damages sums payable for compensation. They're not fines. Okay, this is probably the most important aspect, certainly from a practical point of view. During the period, and it's number 2, I've highlighted it in yellow, during the period of the insurance, the assured shall give immediate notice in writing to the underwriters via the broker or the agent of every letter of claim, writ summons process for malpractice or alleged malpractice against the insured. Put simply, that means a claim letter or a court proceeding. That's quite straightforward. Number 2, the receipt of notice from any person of an intention to hold this person responsible. That's getting slightly more tricky. What does that mean? I'm unhappy with the service you provided. I'm unhappy about this. Does this mean that that person is giving you notice of an intention to sue you? Don't know. It's arguable, isn't it? It's arguable. And then this is the last bit, which I really think is important. The third bit, that you have to notify in writing to the insured any conduct or circumstance which is likely to give rise to a claim. for malpractice being made against the insurer. Now, the patient or the patient's family may have no idea what's happened. They may have no idea that they have a right or entitlement to make a complaint, but you know. Now, in those circumstances, under the terms of the policy, you should notify the underwriter of that. Now, of course, there is a tension in this, because the more notifications you give to your insurance company, the higher the premium is.
For the next time.
That's right. But I would always recommend that you should notify your underwriter, because if you failure to notify your underwriter may mean that the policy does not respond to that claim for failure to notify. And I think it's prudent that claims should be made for all three circumstances.
I just have a question. So you mean that...
Could we just give you the microphone? Thank you.
Okay, so my question is in the part where you said, so I'm supposed to tell them whether there's an actual claim or not? Like, if I have a claim in the court, this is where I have to tell them?
No.
Or even if I just have, like, these situations, someone
Yes.
complains. So in all cases, I
yes.
should tell them?
Certainly, receiving a summons through the court, you should tell your insurance
Yeah,
company.
this is, yeah,
Right.
for
Now,
sure.
that's,
The other part...
I think everyone can accept that that's a reasonable expectation. The second aspect is
That's my...
an intention. So you've got notice of an intention. Someone writes to you and says, I'm very unhappy about the service you provided. I think you should give me a rebate from my bill. Now, is that a receipt of an intention? Perhaps, perhaps not.
Exactly.
So, rule number one, err on the side of caution. If you think it is an intention, tell your insurance company. Tell them.
Even if we sort it out, because I had something like that, that was, where is my question? I had an issue like that where, and